Well, good morning, everyone. This is the third day of Washington Arbitration Week 2025. This is our sixth edition of Washington Arbitration Week. We started off very small in 2020, entirely virtual, entirely limited. But we did go for a week, and we had incredible take-up. Folks were really motivated to join the Washington arbitration community to get to know each other better. We had a definite networking function, although we did find out that I network so much on Zoom. We set up that way as well. Discovered. So over the course of the development of the last 6 years, we kept that virtual element. So we are online, and we always have international folks coming online to see what's going on in Washington. So I think we're a little different than a lot of the arbitration conferences in that we still are virtual. Our registration is for free. We're very focused on introducing arbitration, not just to the experienced practitioner, but to students and anybody, frankly, interested in the work we do. So welcome to everyone here today and online. I guess I should have introduced myself because I'm going to introduce our moderator. My name is Ian Laird. I am co-chair of Washington Arbitration Week, along with my colleague, Dr. Jose Antonio Rivas. He and his folks at X Strategy played an incredible role in organizing this conference, and you've probably seen Maria Adamala's name and Momin Mohsen's name and various other folks from X Strategy. They really keep the trains running on time, and I can't thank them enough for all their hard work pulling everything together. Yeah. 5 panels this year, a number of workshops, as well as receptions. It's really grown, and the take up and enthusiasm from our sponsors has been really impressive. All the law firms who do arbitration embrace the conference and have made it really quite the week for folks to get to know each other better and to promote Washington as a place of arbitration, which I think rightly is becoming one of the more leading centers. We certainly already lead the field in investor state arbitration, but in commercial arbitration, I think we're holding our weight. Even though New York is always there and a short train ride, but I think Washington has great institutions, great courts, and it's a great place to do this business. Anyways, that's my small pitch. We have a really interesting panel to start off today. This panel addresses some of the critical issues that, frankly, we're facing not only in the arbitration world, but in the economic world. The whole topic of construction and infrastructure has really become absolutely existential to the world growth and what's going on right now in so many ways. But I don't want to overstate or create too high expectations, but I think you're going to have a very good panel here. I just wanted to tell you its name. We've titled it International Arbitration, Procurement, and Government Contracts and Construction in the New Geopolitical Landscape. And we have the privilege today of having this panel moderated by my colleague, Michael Guiffre, who's a partner here at Crowell and Mooring. Michael's a member of our International Dispute Resolution Group. He's been a trial lawyer, litigator, arbitration practitioner for over 25 years with global disputes experience. And he served as lead counsel in international and domestic arbitrations in federal and state court litigation across the United States. I love working with Michael. He's a real disputes lawyer, whether he's litigating or arbitrating or just solving problems for his clients. He's a great colleague, and really looking forward to hearing the panel. So I'll pass it over to Michael.
Thank you, Ian. I am not going to stand at the podium because, oh, you're taking the laptops away. Good. I can stand at the podium. Otherwise, I was envisioning myself as a server in a restaurant holding a platter with a bunch of glasses and spilling things everywhere. Okay. Well, I'm honored to moderate today's panel on a topic that sits squarely at the intersection of law policy and global commerce. How international arbitration, procurement, the construction industry, and government contracting are evolving in response to the new geopolitical landscape. It's quite a mouthful, but it is really an interesting time that we are living in an age of transformative geopolitical issues like conflicts, trade wars, sanctions, shifting alliances. These are no longer background noise. They're front and center forces that are shaping the way infrastructure is financed, built, and litigated. They're all over the world, from Eastern Europe to the Middle East to the Americas. And political risk is now, thank you. Political risk is now a core variable in contract design, project delivery, and dispute resolution. In this environment, governments are rethinking procurement strategies. Cost efficiency is no longer the sole driver. We're seeing a shift towards strategic sourcing, modular contracting, and innovative procurement platforms. Each of them are bringing new legal and operational complexities. For construction firms, the ripple effects have been very tangible. Tariffs and export controls are inflating material costs and disrupting supply chains. Tender pricing now reflects not just commodity volatility, but political uncertainty. And in many regions, local laws are clashing with international norms, especially when it comes to dispute resolution. And that brings us to arbitration. In politically sensitive or cross-border projects, arbitration remains the preferred mechanism for resolving disputes. It offers neutrality, enforceability, and adaptability. And these are qualities that are increasingly vital when local courts may be politicized or inaccessible. But arbitration is also evolving. Arbitrators are being asked to interpret force majeure clauses, hardship clauses, and to do this in light of global disputes that were once considered unbankable. So today we'll explore how these forces interconnect, how the governments and contractors are adapting their procurement and contracting strategies, what innovations in contract design are helping parties build resilience in their projects, and when performance becomes impossible due to sanctions or tariffs, what role does arbitration play in resolving that fallout? So our panelists today are Lily Khoury, Jennifer Haworth McCandless, Courtney Dolinar-Hikawa, Rafael Boza, and Rob Burton, and they each bring deep expertise across law, policy, and industry. And I'll be inviting them to share not just what's happening, but what's next. So let me introduce our panelists. First, Lily, to my right, is an associate at Steptoe. She's an expert in investor state arbitration, international arbitration, and public international law. She's also proficient in handling U.S. court proceedings related to arbitration, including actions for the recognition and enforcement of foreign judgments and arbitration awards. And her practice spans a diverse array of industries, including mining, oil and gas, construction, pharmaceuticals, retail, and telecommunications. She has extensive experience litigating disputes or involving disputes in the Middle East and Africa. And she has participated in proceedings in English, Arabic, and French. Jennifer is next to my right, and she's a partner at Baker Botts. She is a leading authority in international arbitration. She focuses on investor state disputes, and she represents both private sector investors and sovereign states across the globe. She also spans a variety of economic sectors, including electricity, mining, oil and gas, infrastructure, real estate, and financial services. And she has a particular emphasis on the Americas. Jennifer's work has earned her consistent recognition, including in rankings in chambers for international arbitration. And her commitment in the field is further demonstrated by her contributions to the U.S. State Department's Advisory Committee on International Economic Policy. Next is Courtney. Courtney is a senior counsel at Norton Rose Fulbright, and she's well known for her expertise in international dispute settlement, particularly in investor state arbitration. She adeptly represents both cross-border investors and respondent governments in high-stakes proceedings, and her extensive experience includes arbitration under investment treaties, government contracts, and also free trade agreements. Her practice also spans a variety of industries, including energy, infrastructure, financial services, life sciences, healthcare, and transportation. And for those who may want to test her after our session, she's fluent in French, Spanish, Japanese, and Italian. Next is Rafael Boza. Rafael is a special counsel at Pillsbury. He specializes in international arbitration and litigation. Rafael has advised multinational companies in arbitrated and litigated disputes throughout the United States, Latin America, and Europe, including proceedings conducted in Spanish. He has extensive experience serving as an arbitrator. He's also an accomplished transactional lawyer with a deep understanding of contract law across multiple jurisdictions, and his background as a former in-house counsel for major European companies gives him unique insights into legal operations, risk management, and compliance. I'm not sure he can figure out what he wants to do with his life with all of these various things that he is an expert in. And finally, we have Rob Burton. Rob is a partner in our government contracts group here at Crowell and Mooring, and previously he served as a senior acquisition attorney in the Department of Defense. He later became the acting and deputy administrator of the Office of Federal Procurement and the Executive Office of the President. And I'll just note that he was the highest career procurement official in the US government. In the private sector, Rob has served as an expert witness on government contracts issues in dozens of court and arbitration proceedings. So we're honored to have this fantastic panel share their insights and expertise with us today, and I will sit down and join everybody to ask questions. So let's go ahead and begin. First, let's talk about geopolitical risk and its impact on contracting. And I'll start off with Lily. How have recent geopolitical shifts, such as armed conflicts, trade realignments, and sanctions, impacted international construction projects, procurement, and government contracts?
Thank you, Michael. Thanks everyone for coming. A big thank you to Ian for having us here today, for all the organizers of Washington Arbitration Week. This is my second year participating in this, and every year I have a feeling it gets bigger and bigger, and there are more and more panels. So thank you all for giving this first day of fall sort of time to spend with us. In terms of the geopolitical risks and their impact on construction projects, it's kind of the name of the game for so many of us, right? We do construction arbitration because there's this geopolitical aspect to it. And so much of it feeds into, who's financing these projects, who's building them, where are the materials coming from, where's the labor coming from, how are these being litigated? And so much of what goes on in the world geopolitically impacts every single stage of the chain. So I'll just in the name of brevity, I'll focus just on these three. Trade realignment being the fun one, because that's really changing the name of the game for everything. Sanctions, because it's impacting, companies, not just from a compliance standpoint, from, caution all throughout the, supply chain. And then armed conflict, because every single time we think things are under control in one area of the world, they light up in another area. So let me start with trade realignment. And the sort of fun part for the last decade has been seeing how the shifts have been occurring in financing of projects and the location of projects. So the one I'm going to focus on today is China's Belt and Road Initiative. So about a decade ago, 12 years now, China starts this massive project, essentially to start financing the construction of projects, highways, networks, linking China to Europe and Africa. At this point, I think the funding has exceeded something like $1 trillion. About 150 countries have signed on to cooperation agreements, contracts to participate in this. And we've seen it in every single sector of the construction industry. Investments in ports. So much of the ownership of Greece's Piraeus port is now Chinese. We have highways, roads, networks, cement plants, steel plants, all the way around, which means that goods and services are being able to circumvent usual transportation networks and just go straight by land from and to Europe and Africa, to and from China. And that's changing so much of the labor, so much of the focus of construction projects, and then so much of the disputes. This is the first time we're seeing many, construction contracts with Beijing as a center, as a seat of the arbitration, with Shenzhen, with Shanghai as a seat of arbitration, being arbitrated in Cairo. We're seeing, contracts that provide for Chinese law and a much greater need for arbitration counsel who either are fluent in the language, fluent in the culture, fluent in the law and precedent. That's driving a fair bit of sort of the geopolitical changes that we're seeing in the landscape of arbitration. The armed conflict, I think I'll leave the Red Sea, Middle East fiasco to when we're talking more sort of geographically about regions. The one I'll focus on right now is just the war in Ukraine, because we're more than 3 years in, and we're still seeing the repercussions of the war in every single stage of the construction projects, right? Fuel prices still went up. Supply chain disruptions are still rampant. Sanctions have had a large impact as to how contractors source materials. Who are you subcontracting with? Are you sure that you're in compliance with US sanctions, UK sanctions, EU sanctions? What do your local laws say about how much of your supply chain needs to comply with these sanctions? Are you as a contractor liable for your subcontractor supplying materials from a sanctioned entity or, an entity that's connected to sanctioned persons? We're seeing a lot more. We used to see a lot of force majeure clauses in contracts that have, very simple, straightforward, provisions for war, for conflict. Usually they didn't really have sanctions involved. Doesn't that now count as a force majeure? We're getting extended transit times when you need to, redesign your supply chain. Who bears the cost of that? So there's a fair bit of rebalancing that a lot of us who practice construction arbitration are having to do, and a lot of the companies who do the construction work are having to do. And that's sort of where we stand for now.
Rob, can I ask you, have you seen shifts in US policy impacting international projects?
Well, yeah, sure. I mean, it's actually been huge. I just want to take this opportunity to thank Ian and Michael to have a government contracts guy with all these international arbitrator experts. And I do want to make it clear, I only speak English, as opposed to some of my colleagues here on the panel. But let me, and I thought you might be interested too in what's happening with the Trump administration. So tariffs, right? I mean, this is just absolutely huge, and it's having a huge impact on government contracts and international relations both. The administration has a very strong preference for American-made products. You probably have figured that out. And you might be the first to know the White House is currently working on an executive order as we speak, on which the president will issue, and I'm not sure when, but it's going to be on Buy American. It's going to have major repercussions here with respect to the geopolitical risks that we're currently facing. The Biden administration also had a great emphasis on American-made products, and they established at the White House something called the Made in America office. That office, the Trump administration has retained and has actually increased its influence in the federal government. And it will have international, it is. I mean, everything's going through, almost every procurement is going through the Buy American office there it actually sits in the Office of Management and Budget, which is within the executive office of the president. And it's a very powerful office. It was during the Biden administration. It's even more powerful now, but no question about it. And all of this Buy American emphasis and pulling manufacturing to the United States became quite clear to me in a recent meeting I had with a very high-level agency senior procurement executive. I brought a client in to meet with this gentleman, and it was really an interesting conversation. He said, you know, I know you guys are complying with the laws and all that nice things, and you're compliant, but that doesn't really matter to me. And you need to understand that this is all about policy. So if you want to be successful in the future and you want to be competitive with respect to U.S. government contracts, you're going to have to move your manufacturing facilities out of Europe and to the United States. And I would say to do it over the next 5 years. That would be my recommendation to you. And so just saying, hey, we're compliant, we comply with the Buy American Act and so forth, that's nice. But from a policy perspective, you're not going to win in the future unless you pull those manufacturing facilities out of Europe and to the United States. I thought that was a real eye-opening comment that he made. He was very transparent about it, that's where we're headed. You know, we're headed in that direction. And this is obviously consistent with the administration's policy of closing USAID, right? That was amazing. Matter of fact, I had a meeting just 3 weeks before the closure with the senior procurement executive at USAID. I was in there, and that poor guy, you know, he's now with a government contractor, working with a government contractor. So he landed okay. But there goes the procurement office at USAID. Truly remarkable. And all of them are out on the street. But what does that message send? What does the closure send? It says, hey, look, we're not going to do as much spending with respect to foreign aid and grants and contracts, and this is going to have international impact. It's certainly creating supply chain risks. The tariffs obviously are huge with respect to creating supply chain risks, and government contractors are struggling with this, right? In the United States, government contractors are really struggling with this new approach to international procurement, if you will. Obviously, all of this money from USAID now disappearing is going to have a huge international impact. And the closure of USAID is in court litigation right now. But let me tell you, my prediction is that all of these projects and contracts that the Trump administration want to cancel will be canceled. I think in the final analysis, they are gone. And you have to understand, too, in the United States, we have an incredible power with respect to terminating contracts. It's called termination for convenience. And believe me, it's very hard to challenge. It's very hard to challenge a termination for convenience. So all of these contracts at USAID could have been terminated with the power of termination for convenience without closing the agency. I mean, the government still had that power to do that. So I think in the final analysis, these projects are gone, and that obviously has a worldwide impact. And my prediction is you will see more international disputes and international arbitration because of the administration's position on tariffs, on USAID, and on Buy American. All of those are related, and all of those are really going to be pulling money from grants and contracts from the international stage back into the United States.
Rafael, just following up on those comments, are you seeing any effects of U.S. or other geopolitical shifts in various regions around the world?
Absolutely, Michael. Thank you. And thank you to Ian and Jose Antonio and the organization of WOW for inviting me to speak today. Thank you all for attending as well. I'm going to focus particularly on Latin America, I guess. from my perspective in Latin America, and Lily has set the stage perfectly for me. There are those three problems, let's say, in the generality of things: trade realignments, supply chain disruptions, and political and military tensions again in the region, specifically Latin America. We are seeing, in particularly next year is a very interesting year because we will see the renegotiation of USMCA, and we don't really know where is that going to go. It's very likely that there will be very high expectations, let's say, from the US government on Mexico's crackdown on crime and particularly narco activities, let's say, in Mexico. We see news every day from Mexico that the narcos are taking over cities, basically, closing cities to the general public and imposing curfews and other things. Of course, there's extortion that is rampant in Mexico, and that impacts not only the trade, but also all the criminal activity that happens in the border, which is a focus of the Trump administration. Also, the tariffs are having a huge impact on the relationships with Latin American countries. Most of them are subject to a 10% tariff, despite the fact that many of the countries in Latin America have trade agreements with the US. So that is causing severe trade disruptions, including the possibility of bringing agri-industrial products from Chile or Peru to the United States, which is a huge source of revenue for those countries. So we are seeing realignments down there from that point of view. Also, supply chain disruptions because China's economy has been affected by the tariffs that the Trump administration has imposed. Already, we are seeing effects on the Chinese economy from those tariffs. What does that mean? That the Road and Belt Initiative is taking a second or a secondary priority for the Chinese government. That means that there's less money in Latin America for investments. We're seeing, for example, the port of Chancay in Peru is taking a little bit more time than what the Chinese originally intended to have, and the operations of that port are taking longer than what was planned. Russia's war on Ukraine, as Lillian mentioned, also is having a huge impact because Russia was a lifeline for countries such as Venezuela and Bolivia, Paraguay as well. That money from Russia is not coming to those countries anymore. And we're seeing how the Trump administration is taking advantage of that particular issue in Venezuela in this last few weeks, where they have basically put an embargo on Venezuela and are blowing up, drug boats allegedly here and there. So that is putting a lot of tension in that particular coastline. That brings me to the third point, which is the political and military tensions, which is possibly regime change in Venezuela. Regime change in Venezuela would be huge, not only for purposes of the fact that the US doesn't recognize the Maduro regime as a legitimate government, is considered basically a narco government. And if the pressure that the Trump administration is putting on Venezuela would cause the Maduro regime to fall, it would be huge for the region in general because it will have ripple effects in Colombia, Peru, possibly Brazil. Who knows? It's really one of those things that you cannot anticipate. So lots of things happening in Latin America. Keep an eye on those because it's going to be an exciting year, 2026, particularly Mexico, and I expect a lot of changes coming up.
Thank you, Rafael. Would anybody else like to speak to other regions around the world that are being impacted by geopolitical shifts? Maybe Lily?
I'm happy to speak about the Middle East because we're having an equally busy period, both in terms of good news and bad news. The good news is there's a lot of efforts to revitalize and diversify the local economies, Saudi Arabia being, the prime example. The country's Vision 2030 project is alive and well. There are massive investments being made into the NEOM project, all sorts of these giga projects that are just scales beyond what usually we see in sort of economic diversification. And what's that doing, as Rob mentioned, is it's introducing a lot of, at least in Saudi, local procurement laws that, companies and investors now have to comply with. So, it's not sufficient just to invest in Saudi as a foreign company and then bring in your foreign labor and your foreign materials and just, get the job done and get out of there. Now there's, the local content and government procurement authority, which requires you to make sure that you are adding value into the local economy. So you're hiring local workers, you are sourcing materials locally. A lot of times you need to have a local office there. So I'm sure a lot of us know, our own law firms or our sister law firms are now opening offices in Saudi Arabia, in Riyadh in particular, sometimes in Jeddah, sometimes in Tehran, if there's an oil and gas component. So that is, really changing the landscape locally in the Middle East as to how, projects are being made, investments are being made. And then on the less good news front is there's still a lot of armed conflict in the Middle East. And so one of the shifts that we're seeing very clearly is, the disruption that's happening, for example, due to the Red Sea crisis. We're on our second year of the Red Sea crisis. If you're following, essentially, it's commercial vessels are being attacked. So essentially everything that used to be routed through the Red Sea and the Suez Canal now has to be rerouted through Southern Africa, the Cape of Good Hope, which means you're building in delays of 2-3 weeks into every supply shipment. You need to account for, changing your supply chain if you need to, get materials from a different location because all of a sudden it's way too time consuming and expensive to get it from your usual locations. You need to account for the fact that if you have a project in Jordan or Egypt, it's going to be more costly. Now it's going to be more delayed. You're going to have claims up and down the chain from your subcontractors with your owner due to these disruptions. And you may not be able to rely on your contractual provisions because this isn't really a war. This isn't a change in law. This isn't something that fits nice and squarely into a lot of the boxes that usually are being contracted for. And so it's giving a lot of work to a lot of very sophisticated colleagues of ours and our law firms to try and make sure that, if you have a company that does that sort of business, that you're able to allocate risk in your contracts to account for it.
Very insightful. Thank you. So let's shift a little bit. Let me go back to Rob. Are you seeing any changes in project priorities with governments, and is that affecting the procurement framework associated with that?
Well, yeah, let me again just focus here on the United States, which I'm most familiar with, and I'll take a couple of areas. So the Trump administration is very concerned about semiconductors. They're clearly putting a new focus on trying to move the manufacturing of semiconductors to the United States. Most are foreign made. Most semiconductors are foreign made. And you'd be surprised how many items have semiconductor elements in these products. And I think the Trump administration was shocked when they found out exactly how much it was being manufactured abroad with respect to semiconductors. So there is a huge emphasis right now to shift that manufacturing to the United States. Also, new emphasis, much more so than during the Biden administration, there's a greater emphasis on manufacturing and stockpiling of munitions and critical rare earth materials. So this is at the same time, right, that Europe is very concerned about the same thing, and they're trying to enhance their own defense capabilities. So there's almost competition here going on with respect to the munitions and the critical rare earth materials. I think this is a whole area that is in need of increased international cooperation and international agreements. I think there's no question we're going to see a lot of movement to have international agreements on these munitions and critical rare earth materials. There's going to be a fight, if you will, to get as much as you can. And obviously, there are limited resources. And I think this is going to require a lot of careful procurement planning too, especially here in the United States, and how to deal internationally with trying to come up with cooperative agreements. I think that's where we're headed. Obviously, at the same time, there'll be increased disputes and I think need for arbitration. This is a great time for you guys, by the way, for arbitration. Now, moving to a shift with respect, this is a huge shift with respect to clean energy infrastructure projects, right? Biden administration was all over it. We love it. We, love clean energy. Trump administration, just the opposite, shut it down. So this is actually having right now a huge impact. You're seeing cancellations of major solar, wind energy projects. International clean energy developers have invested significant sums of money already into these projects that are being canceled. So I guarantee you that will be an area of increased disputes and arbitration. And again, right, they're looking toward canceling the contracts, which is going to have a huge international impact. Then let me turn now to cybersecurity. Cybersecurity certainly was of interest to the Biden administration as well as the Trump administration. What is happening right now is the Department of Defense in particular has put in these very stringent requirements to be cybersecurity requirements, we'll call it. And they're very expensive to comply with. Small businesses are going crazy. They're like, oh, we can't deal with this. It is going to, these requirements, because they're so stringent, it is going to decrease the number of new entrants into the federal marketplace. At the same time that the Trump administration wants to attract new entrants into the federal marketplace, especially they're looking for innovative technology that really exists only with commercial companies that are not currently doing business with the US government. And so the Trump administration wants to attract these folks, but these cybersecurity requirements are onerous. And a lot of commercial companies are sort of like, thanks, but no thanks. We don't want to take the compliance risks that would be associated with these new cybersecurity requirements. So this is going to be a real challenge moving forward because there's an obsession, almost an obsession over the, and rightly so, arguably, with respect to the cybersecurity requirements and new compliance requirements in that regard. So I think that this is going to be a real difficult area with respect to U.S. procurement and trying to come up with some balance between the need for cybersecurity protection and the need for innovative new commercial companies coming into the federal marketplace. And of course, the U.S. government has always been trying to get more small business participation into the federal marketplace. That hasn't gone too well over the last decade. The number of small businesses doing business with the U.S. government has decreased dramatically. Of course, the entire industrial base, I mean, the number of contractors doing U.S. government contract work has decreased dramatically. But and this is an issue. I mean, this is an issue the Trump administration is struggling with, is how to get more creative, innovative companies to do business with the federal government. And obviously, that would have international implications as well.
So let me ask, does anybody else on the panel have any views about other types of shifts in procurement priorities or other ways that they're handling procurements outside of the United States?
Very quickly, Michael, just to mention things that are happening that are very important, I think. First, the shift, as Robert said, to the data centers in the United States. There are 3 executive orders now that are going to focus the attention of the government into data centers. And data centers, as you know, are massive, massive capital-intensive investments and require not only the technology, but also huge amounts of energy. So the government is trying to incentivize nuclear energy for those projects as an alternative in micro reactors, for example, so that a Google data center that requires the equivalent of a small town with 100 megawatts of energy could be built, I don't know, in the Dakotas or somewhere around there, where there's a small reactor next to it that feeds all the electricity that data center needs. The other thing that also Rob mentioned that I think is very important for the Latin American practice is the rare earth minerals. We're going to start seeing a lot more of that mining. And with that, we're going to see a lot more of social conflict coming up. We're going to start seeing a lot of possibly international arbitrations coming from that sector, including in Argentina, northern Argentina, southern Bolivia, where there's a lot of lithium that is needed for batteries that we are seeing in every single vehicle and every single device that we have. Then we are going to see the actual rare minerals that like cobalt and others that are very abundant in the Andes in general, the region in general, but that's also a very, let's say, sensitive environmentally area. And there are many, many communities in the area that are not friendly to mining, not only because they're worried about their environment validly, but also because there's a huge amount of corruption and there's a huge amount of illegal trade of minerals that is disrupted when you have legal mining. So when legal mining comes in, those illegal miners pay the communities to disrupt the legal trade so that they can continue with their illegal trade. And that is a huge problem. So we're going to see, I think, the government's taking a more aggressive stance regarding those activities and also taking creative approaches to their contracting. And basically, they're going to be looking at creating resilience in those contracts and traditional infrastructure contracts, such as ports and roads and things of that nature that we have seen. But they're going to change their approach to those contracts and create a more resilient and less prone to disputes, let's say, approach to contracting, a more preventative.
Thank you. Let's go ahead and shift it up a little bit and talk about arbitration and litigation in the fragmented legal landscape here. And Jennifer, I was curious, what kinds of disputes are you seeing as a result of geopolitical issues in terms of international construction or procurement projects? Are you seeing anything arise?
Well, and actually, just said before what Rafael said, I mean, it's not necessarily new, but social conflict as a kind of in particular, investor-state arbitration. So speaking from that perspective, social conflict has been a component of investor-state arbitration, in particular in the mining sector. I think that that's something that will probably continue to grow as the development of mines continues, investments in mines continues. I mean, the way it shows up in the context of investor-state arbitration is local communities. I'm not sure about the twist if it's the local community isn't like authentically protesting, but coerced from illegal mining. That would be an interesting twist. But usually the way in which it happens is, or it has happened in investor-state context, is the local communities who are affected by the investment. So if there's a foreign investor in the context of investor-state arbitration investing in the local community, say for mining purposes, if the local community is adversely affected by that, be it from environmental reasons affecting the water, or even just that, which happened in one of the cases in which we were involved, in which we represented Peru, which is Bear Creek case, even in which it's the investors didn't necessarily do sufficient outreach to the local communities before and while they're making the investment. So local communities feel disenfranchised and are not receiving the benefits of that investment themselves, and so can get into actions which prohibit or restrict the investment or cause problems for the investors. They can create protests, they can block roads, they can invade the space, and then the government wants to and needs to take action. And then the question is how and what way do they take that action? They can take action by taking measures that affect that investment, or they are obligated often under international treaties to at least exercise due diligence in trying to protect the investment in the sense of the space in which the investment exists. But sometimes it's very difficult for them to do. And so in some cases, for example, in the Bear Creek case, where the investor needed to have permit is essentially an authorization from the government in order to invest in the region in which they're investing, which was close to the Bolivian border. The protests were causing such a problem for the investor that the government, in order to affect that, to contain it, to manage it, decided to revoke that authorization. And I'm not sure that in the end there was found to be a breach, not a significant amount of damages, but I think there's partly because of the issue that the tribunal found, which was in relation to whether or not the investor did enough in order to allow for those to protect the local communities, or to help them to get like a social license for them to be kind of also a part of the investment, or at least benefiting from the investment in a positive way as opposed to a negative way. But it was more the way in which the government had taken that action. So the government had taken that action literally with hours in the middle of the night to revoke that supreme decree, which was allowing them to be able to do the investment. So that was the breach of the treaty in that particular context, was more the way in which the government had taken that action than necessarily the action that was taken if it had been done in different ways, like they had involved the investor, or if they had taken more time, et cetera. So, but the government felt it needed to act quickly given the emergency circumstances. But you see that in a lot of different locations. It's also happened in Panama with respect to the mines that are happening there, and that causes the government to take action to cancel a concession, for example. And so those are real examples of situations where the local communities are affected or adversely affected or potentially affected, and through a rise of protests can impact the investment and the ability of investment to go forward, and government wants to take action, which can lead to problems down the road, especially investor state cases. I think given that there's going to be, because of lithium in particular, there are going to be additionally new mining globally, in particular in Latin American region. And I think that as it has a strong potential of leading to future investor state disputes because of that. Great.
Okay. Let me kind of shift again to the U.S. Perspective. And Rob, do you see, I know there are a lot of changes the Trump administration is making to the U.S. procurement system. And do you see any of those changes impacting the way disputes are litigated or arbitrated internationally?
Yeah, let me just give a little bit of background on what's going on with respect to this, what the administration calls a revolutionary overhaul of the federal acquisition system. And, if you're in my world, this is really exciting because, how often people really care about this stuff, right? And we have a president who's issued over 200 executive orders, and I counted up, there are about 60 that impact the federal acquisition system in some way. And there are 4 or 5 that are directly on point with respect to revamping the federal acquisition system. One of the executive orders said, hey, get that federal acquisition regulation, which is 2,000 plus pages, get it slimmed down, make it more concise, make it more user-friendly. So we've had this team of people over at the General Services Administration, GSA, working very diligently to streamline, move parts, they're doing all sorts of stuff. I don't think it really is going to impact contractors in the short run that much. You have to understand that one of the parts of the federal acquisition regulation contains all the contract clauses. These contract clauses are flowed down to some of our international partners. So the contract clauses are very important, and there's not been any radical changes really to some of those clauses, but they're not done. They are pretty much done though with respect to this revamp of the federal acquisition regulation, and all of the changes are going to go out in a formal rulemaking process now. They'll go out in what we call interim rules, which mean they have immediate effect for public comment, and the public comment time is going to be reduced to just 30 days. It's going to be usually 60 days, but this will be 30 days. It's a very expedited procedure. Again, somewhat unusual in that regard. And the Trump administration really doesn't like all of the requirements that were in the federal acquisition regulation. And this is mainly talking to the acquisition professionals, the contracting officers, and so forth. They have taken over 1,600, the word shall, 1,600 shalls have been removed. and these were non-statutory shalls that were mandatory in nature, they have been removed. Well, what they want to do is give contracting officers and other professionals much more discretion and flexibility in how they apply the rules. I think in the short run, this is going to create more disputes and more litigation. I think in the long run, it's going to be very hard to successfully challenge legally some of the decisions that contracting officers make, because it's all so much more is going to be discretionary. So, and you should also know that the administration hates litigation. They hate bid protests, and they're looking at ways to reduce the activity in that regard. I do think that this administration is much more inclined to have informal dispute resolution, ADR, anything that's quick and fast, anything that's long and drawn out, like court litigation, they really abhor. And you have to understand that that philosophy is influencing a lot of these regulatory changes to our acquisition system. I might note also that as they remove some things out of the federal acquisition regulations, they're putting them into something called the FAR Companion Guide. I love this. And it's only 50 pages, because I was convinced, hey, they're going to move, this thing's going to be like 1,000 pages, right? They're going to move stuff out, and they're going to have this companion guide, which is non-regulatory. It's going to be best practices, things of that nature, that is just guidance. Oh, and then this is sort of interesting. In that companion guide, quote, it is non-regulatory, contains no mandates, and is not intended to serve as the basis for protests or legal actions, unquote. So it's sort of like, don't even think about filing a complaint here, guys, you lawyers, because we're trying to set this up so there won't be litigation. It's called the Companion Guide, 50 pages long. That's not bad, but only 50 pages. I was impressed. But I think bottom line is we're going to have fewer mandatory regulatory requirements. You can't do much about the statutory requirements, although they do have recommendations going into Congress with respect to statutory changes. Nothing dramatic yet, but they think there's too many statutory mandates also with respect to our federal acquisition system. Would like to see that change too. But I think bottom line is this is going to be, in the short term, there'll be more disputes, more arbitrations coming your way. In the long term, with respect to, at least in the United States, I think it's going to be more difficult for lawyers to challenge some of this, because so much of it's going to be discretionary, and it's very hard to successfully challenge discretionary decisions. But the inconsistency I see is a real problem, because we're going to have contracting officers doing different things, and it's going to be very frustrating, I think, for folks that deal with the federal government.
Thank you, Ron. Okay, I apologize to Courtney for not throwing any questions your way yet. So let me hit you with one. Have you seen any shifts or challenges in enforcing arbitration awards where the losing party is a state or a state-owned entity in a politically sensitive jurisdiction?
Yeah, thank you, Michael. And thank you, everyone. It's late in the game to say that, but thank you. I'm happy to hear everybody's comments. Yeah, I wanted to give the example that we're seeing play out right now of Venezuela, which I think maybe many of us are following. It seems like every law firm on the East Coast has been involved in some way or another in this history. But there is a long list of investors who had claims against Venezuela and went to international arbitration, investor state arbitration, and won. And so they have claims that they are trying to enforce now against Venezuela in the United States, against Venezuela's assets in the United States. And sanctions and the history of the US and Canada and Venezuela, the history of those sanctions has really complicated those efforts in a variety of ways. I'd say first, the most basic general complication or difficulty in enforcing in the US with sanctions is that if you want to enforce in the US or use US persons, including lawyers, you will likely have to obtain approval from OFAC, which is a process that can be very lengthy and unpredictable. In the particular case of Venezuela, because there were two regimes and the US recognized the opposition as opposed to the Maduro regime, investors or creditors that were lost sort of in between those two governments attempting to enforce their awards in the US or their claims in the US have to seek validation of those claims in US courts. So recently we saw, just a couple of weeks ago in the Southern District of New York, we saw a decision, a holding come out that defaulted bond note holders or the defaulted bond notes were valid under Venezuelan law, despite the fact that the Venezuelan government, the one recognized by the US, had advocated for the opposite conclusion. And so the result of that decision then intensified this clash between judgment creditors in arbitration with arbitration awards and these bondholders who are all vying for different assets of Venezuela in the US. So these cases are more than 10 years old. This is going on. Who knows how long it will be until they're actually able to enforce some of these awards. But I also wanted to say, in terms of sanctions, what I think is very interesting is I wonder, we think of sanctions as sort of the force majeure on the side of the contractor, the investor, as an excuse or a problem. But I wonder if in the future we'll see governments trying to use that as a defense in investor state arbitrations for discriminatory or arbitrary actions. So that's, and I don't think we've seen that yet. And I don't think we've seen how a tribunal would rule on those questions.
Thank you. Did anybody else have any follow-up on the enforcement of arbitration awards?
I can jump in on that just because you just mentioned the sort of the states using the sanctions. And I've always found it interesting when Russia started imposing the counter sanctions. So essentially telling, so the classic sanction, the classic Russian sanctions are, you know, if you're a foreign investor, you can't be dealing with, contracting with, you know, sourcing from certain sanctions entities, either by the US, by the UK, by the EU, in Russia. And then all of a sudden you have Russia imposing these counter sanctions, which essentially penalize companies for their compliance with EU, US, UK sanctions. And that, I mean, that has got to get to a tribunal at some point, because you're putting the contractor in a position where you either have to break local law or you have to breach the contract. So, you know, choose your evil. But I was also going to jump in on enforcement in terms of sort of meta developments, because it's one area where, you know, things are actually looking pretty good. And there's been a fair bit of activity over the past 5 years with a lot of the countries either revamping, revitalizing, modernizing their arbitration laws, which includes the enforcement chapters, and making it a lot easier for awards to be recognized and awards to be enforced. Now, there was always a workaround, because if you're enforcing against the assets of a state in the Middle East, you're generally not enforcing it in the Middle East. You're enforcing it against state assets in London, and in the UK, and in Europe, in the US, where those countries generally do have assets. So there was always a little bit of a workaround. But if you're trying to enforce locally, it's a very bureaucratic region. You have a lot of local laws that will put in either public review requirements, like in Egypt, or you'll have, countries like the UAE that has like ministerial oversight every single time you have a contract with, a private public entity. Anything that is politically sensitive, that review can be even more substantive than just procedural. So that was somewhat of a challenge if you wanted to enforce awards locally, and that is somewhat fading away with these, revitalization efforts that are designed to bring in investment. So you want to make sure that you are giving comfort to investors that, if you ever have a dispute, if you are using, our bilateral investment treaties as a means of protection, if you're, relying on DIFC courts in order to arbitrate your disputes, whatever you're doing in the region, you're going to get the comfort of an enforceable, even executable award against us if need be. And so that's been a very positive development over the last few years.
Great. Let's shift a bit to kind of our final topic since we're running out of time. But let's talk about innovations to manage political risk. Are you seeing, and maybe Courtney and Jennifer, since I haven't given you many opportunities to talk, have you seen any changes in the way the parties are using alternative dispute resolution clauses to manage geopolitical risk?
I think not necessarily clauses, but I get a sense, and this may be representation bias, but I get a sense that investors are worried or concerned. There's a heightened sense of risk with all the political turmoil that we've been discussing. And they are looking for ways to mitigate those risks. There are not a lot of ways, so I'm a little bit pessimistic about it. But one way to do it is some investors have been looking at what we call treaty planning, structuring their investments so that they pass through a jurisdiction that has an investment treaty with the government that they're planning to invest with, so that they can use that jurisdiction, that usually a special purpose vehicle located in those jurisdictions, to avail themselves of the protections of the investment treaties and have access to international arbitration. And that's I think it's great. It's great for what I do. I love thinking about that and doing that because it's fun. You get to think about, oh, we'll go through this country and then you'll protect to this treaty. It's kind of difficult though, because a lot of countries are withdrawing from treaties, or they're, further limitations on who can access investment protections. I feel like there's a general trend sort of in treaties to be more narrow and to exclude certain types of investments and jurisdictions. So that is a challenge. But I do think that that investors are looking for ways like that to find protections.
Yeah, I would agree. And I think kind of investing through a particular vehicle and considering how you're making that investment in a country, in particular, if the country is volatile or you expect the country to be volatile, is pretty important. And you have to think about it in advance. One of the kind of cautionary tales is first of all, you have to look and make sure that if you invest, depending upon how many layers of investment there are, if it's an indirect investment into the country, that you'd still get the treaty protection. So you have to really be careful in how you analyze how you're going about reorganizing yourself in order to be able to get the protections of the treaty or treaties or the free trade agreements. But also you have to be careful not to do it at a time in which a dispute has already arisen or is foreseeable to arise, because that is considered to be an abusive process and you won't be able to get jurisdiction in the end. So you do have to do it well in advance. So if you're looking to invest, you have to, and restructuring is great. Doing it now, I would suggest, for example, in Argentina, for investments in Argentina, because now there's a great encouragement of foreign investment, and there are laws that are being passed to encourage investment in many different sectors, including in oil and gas. And that's great now with the current administration, with the potential of having a change in administration. And as in many countries, with a change in administration will often shift what has just been encouraged by one government to just the opposite, then those rights and the protections that currently exist may be taken away. Therefore, one would be advisable to make an investment wisely in a way in which you get protection in country where, while it might look good now, take into consideration the fact that laws can and do change based on who's in government, advisable to make sure you have those protections by investing through a vehicle which will allow you to get that protection, and doing it in advance of the actual adverse action, in particular investor state context, where the government would take adverse action, because you can't get the benefit of that protection if you do it when it's imminent and foreseeable and just about to happen, because tribunals won't allow that to happen.
Great. Yes, Rob.
I do have an innovation that I think it's important to discuss. It's not so new, but it's being used more and more. And I think the Peruvian case, and I've been speaking about a lot of Peru, but I think the Peruvian case is an interesting one and should be studied and imitated. Peru is one of the few countries in the world, I think the only one in the world, that has by constitution the obligation to arbitrate disputes, and their procurement law requires the state to arbitrate all disputes against all suppliers and contractors. So since 2017, Peru has adopted something that has been kind of developed by initially FIDIC and the new engineering contract by, I think it's a London entity, the NEC tree version, is the disputes boards. And since 2017, the Peruvian procurement law requires the implementation of disputes boards in contracts over 40 million soles. So that's about $10 million, $15 million. The dispute board was used heavily during the Pan American Games in 2017 or 2019 rather. And the statistics that came out from the Peruvian government is that disputes were resolved in 72 days average versus 600 days average for an arbitration. And the projects didn't stop at any point in time, so that they could be delivered on time and relatively on budget. But let's be real, the Peruvian government, as well as every other government in the world, are not very good at managing their projects. And one of my friends, Luis Rey, is putting out an article with the statistics about this that say that about 100% of government projects are 28% delay on average and 25% overrun on average, with the egregious example of California's train with 60% overruns and 10-year delay. Oil and gas projects, for example, private oil and gas projects are also not an exception, with about 15% overruns and 30% average delays. So the dispute boards seem to be a real solution to maintaining projects on track before they fall off and we have to go to arbitration, which is kind of a post-mortem kind of a process once the dispute has been going for a while. So that's an innovation that I think is important to consider, and the Peruvian case is an interesting one for those policymakers in different countries who could adopt something similar.
And how about you, Lily? Have you seen any contracting innovations to handle politically sensitive environments?
A couple, but as Courtney said, and just between us in the room, everybody watching us live and the recording for posterity. I don't want to say we're pessimistic about them, but there's room to be cautious, right? There's a couple of different ways you can allocate risk. One is we're seeing a bit of a rise in modular contracts. So instead of the traditional construction contract and EPC contract that tends to be on a lump sum turnkey basis, here's $1 billion, please build me a power plant. We're seeing contracts being cut down into modules. So essentially broken down into small parts. Each would have its own risk allocation, sometimes its own financing, sometimes its own schedule, its disruption. So you can essentially have a module be delayed, have a dispute over it, arbitrate the dispute, go to a dispute board, and have the other modules remain intact in theory. In practice, it's a seller's market. So, do you actually have the leverage to be able to negotiate that when you have, an owner, an employer who wants a construction project for this price, this time duration, and if you're not willing to provide that service, there are other contractors on the market. So it's a good idea in theory. Sometimes it's applied in Saudi Arabia's, giga projects in NEOM, it's being applied, but, the state has a fair bit of leverage in order to be able to sort of impose that condition. Contractors, whether or not they do is a different issue. And then the other one is, and that's sort of to account for disruption delays. The other one, which is to account for economic delays, is essentially to have dynamic pricing. So instead of saying, please build me a power plant for $1 billion, you can index some things to cost of materials, to inflation rates, to whatever metric it is that you think is relevant for that project. And if things change on the ground, then the price is dynamic. It's in the name. We do see that a fair bit. Usually, you want to make sure that you're indexing to what inflation rate is usually the easiest one, to account for unexpected, foreseeable but unforeseen changes. And that tends to work a little bit more because it's a little bit, better visibility for everyone. We all know, prices go up. Maybe the contractor needs a little bit extra wiggle room in order to fulfill the same requirements as before. So we're seeing a fair bit of that.
That's great. Okay. Did anybody else have comments on that?
I'll add that I saw very recently that Ecuador had entered into an investment protection agreement with for a specific project. So I think that's one innovative way to address risks for a specific project. And I think that agreement included perks like stabilization clauses and some other things specific to that investment. And so for that project, that seems like it would help mitigate risk. It doesn't solve it for other investors who are left out maybe in the cold, or smaller investors and small SMEs that also want protections, would need to rely on the investment treaties. But that is one, for big projects, maybe that is one innovative way to mitigate risk with governments.
Okay, great. How about now if I open it up to the audience, if anybody has any questions that they would like to throw curveballs at the panel here? Please.
Question about sanctions, counter sanctions, structures for the secretary of sanctions. So, respect of sanctions, what kind of measures can you take to mitigate the risks before starting a project?
Sometimes very little, and sometimes a lot. It might require essentially redesigning your supply chain. So it depends on what the facts of the project are. Where is it located? Is it located in a country that is subject to sanctions? In which case, there's a fair bit of sort of redesign that may need to be done. Part of it is, how do you actually structure investment in a way to minimize your exposure to sanctions? So one way can be, are you a U.S. entity, let's say, has different sanctions requirements than whatever a UAE entity in terms of investing in Russia, contracting with a Russian entity, whatnot. And it might also be sort of designing your supply chain. So where are you getting, for construction projects, all of your various components for the project? Sometimes it means you're sourcing them from an entirely different location. And you then need to realize, I need to allocate the risk somehow and allocate the cost somehow. So who's paying for my redesigning my supply chain and getting the materials that might cost more elsewhere, take longer to actually get where I need them to go? And then, do I have the local labor in order to implement the project? So it's very fact sensitive. It's very dependent on, what precise project you're looking at, what are the surrounding circumstances, what's the country involved, what are the sanctions involved, who's imposing them. So it's a fair bit of contract work. It's why all of the sanctions groups and all of the law firms are very, very busy and have been for the past 3 years. But it really just depends on the facts.
Thank you. I think we had another question here.
Thank you. My question is also for Ms. Khoury. So you touched on the Saudi efforts to diversify their economy, specifically with the in-kingdom total value add. I would be interested to know if, A, you've seen, or if generally the panel has seen more arbitration, like investor-state arbitration, come out of things similar to that. And then B, as other OPEC countries seem to be kind of heading toward, less of a reliance on hydrocarbon production and, trying to diversify their economies, things like that. If the panel predicts that that will be a significant thing in the future of arbitration?
So not yet. The disputes aren't there yet. The disputes are being promised, prophesized. Everybody's expecting them down the pipeline because all of the transactional work is happening right now. So the rush of sort of foreign law firms, foreign investment, direct investment, indirect investment into Saudi Arabia, into the UAE, into Qatar, Bahrain, even Jordan, the Levant at this point, Syria, there's a lifting of sanctions on Syria. There's a massive reconstruction effort that needs to happen in Syria. There's a massive reconstruction effort that needs to happen in Gaza very soon. All of that comes with construction work and all of that comes with construction disputes, but it's, I don't know, 5-10 years down the pipeline. The transaction work is there. And I think a lot of us are seeing, in our own law firms and sister law firms, a lot of work, going to Saudi Arabia, and no longer just in oil and gas and a lot of other various industries that the government is pouring a lot of time, effort, and money into.
Any other questions? Okay, I have a question just to kind of wrap it up. I guess a takeaway for all of us that I would like to know is, can you tell us what kinds of skills or mindsets or approaches we should take as lawyers and arbitrators to kind of survive and thrive in this kind of changing political landscape?
Well, now, of course, I'm biased, but I do think that arbitrators and lawyers have to really have a good understanding of the public procurement process and some of the best practices. And in that regard, I want to put a plug in for this little book, which I was really honored to chair an international group of procurement experts coming up with international best practices in procurement. This was in 2007. This was sponsored by the OECD in Paris. And I oftentimes refer to it when I give expert witness testimony, because I'm convinced that in most of these, in the court litigation or even in arbitrational tribunals, the ultimate decision maker is really going to be persuaded about what were the reasonable expectations of the parties and what were their understandings of the public in the public procurement industry. What were the best practices? Did they follow them? It comes down to an equitable analysis in almost all of these cases. And sometimes the law is not as important as what is equitable, what were the reasonable expectations, were they following best practices, what does the procurement industry think about allocation of risk, what typically is done in cases like that. It really comes down to that. And I think the US system also, I think familiarity with the US procurement system is helpful. It's certainly not perfect by any means. And I certainly learned that when I was working with this international group. And of course, the Trump administration thinks it's definitely in need of major reform, but it's long lasting, it's robust. And oftentimes I use it for comparative purposes when I'm giving expert witness testimony, because it's helpful in that regard. And I think it's persuasive to decision makers when they're doing these arbitrations and court litigation. And you almost always have some type of procurement issue involved. I mean, I've been in defamation cases, CERCLA, environmental cases, and you go, what relevance does government contracts have to this? There's usually a contract involved, and there's some underlying expectations with respect to how it is performed. And that's where I think if you're an arbitrator or a lawyer in the international arbitration world, having some understanding of the public procurement process and best practices is really essential to your success.
From my perspective, and how can we represent our clients the best, I think three concepts are important: adaptability and flexibility, anticipation of volatility, and incentivizing conflict prevention in as opposed to necessarily conflict resolution, which is what we do at the end of the day.
I agree. I was also going to say flexibility and creativity. I'm going to add to that this because I think the question was skills, mindsets, computer skills, AI skills. I'm just going to count that because I think that in the future we need to be able to use for everything, but it will also be helpful in this area. Yes.
Yeah, in the context of this kind of the changing environment with respect to like politicized global environment, I mean, I think flexibility is top on the priority because you have to be able to be flexible with respect to all the things that change and be able to go with the flow and be able to come up, and creativity too, be able to come up with creative solutions, in particular, speaking as a practitioner and for your client, you need to be able to think outside of the box. So it's super important. It is always important, but it's super important today given the fast changing political landscape, and also be quick to acting. You have to be able to think quickly and advise quickly to come up with solutions for things that are happening very quickly and changing without a lot of warning. And so you really have to have kind of all of those kind of components in order to be able to kind of survive in the fast changing geopolitical changes that are going on today globally.
I mean, I'll second all of that, and I'll add, just because the nature of our jobs is we need to be everything to everyone all at once. Have a piggy bank and just throw money at news subscriptions and read them. You don't want to be waiting for the phone to ring and your client tells you, you have to know your industry. You don't want to have your client call you and say, I have this problem because whatever, we have a sanctions issue, and you tell them, hold on, let me just run it through Claude or ChatGPT or Google what sanctions issues are happening. You want to make sure that you're 2 steps ahead of the curve and you understand what the problems are. And as Rafael was saying, you want to see what's coming down the pipeline and be ready for it. So subscriptions, Financial Times, New York Times, Washington Post, whatever your drug of choice is, use it.
Yeah, that's great. All right. Well, I want to thank you all for a really, rich and thought-provoking conversation today. It's clear based on what you all have said that there is a lot of change, evolving legal frameworks, evolving commercial strategies, and you've certainly underscored how important it is for all of us to be able to anticipate our clients' risks and be able to adapt to them. And so for that, I appreciate your contributions to today's session. So.
Well, thank you, and members of the panel. That was a great start to the day. We're going to have a short break for about 15, 20 minutes. So please help yourself to coffee and food and do a little bit of networking, and we'll restart in about 20 minutes. So we have a great panel coming up next. It's our NAFTA 3.0, which is going to address ISDS and other related interesting issues in the coming year and years. So looking forward to that, and we'll see you back shortly. Thank you.